The advice that I would give to new companies is think long-term and short-term for both. That it is very easy to forget the long-term because you are desperately trying to get all of your short-term ducks in a row. But what you need to do is that when you understand that when you have a business plan, when you are developing your business plan, you have to think about your long-term problems, your short-term problems, your long-term solutions, and your short-term solutions. And you have to keep revisiting those business plans to adapt them over time as new events occur. So you got to keep your eyes on the ball. You got to get your name out there. Maybe it seems like getting your name out there is not that important, but it is, because if your name is not out there, you're not developing your contacts to feed your future business. And similarly, if you're focusing on getting your name out there and not getting your short-term work done, you're not going to be able to pay the bills. I am Muara Moran. I have practiced intellectual property law for a number of years, both in companies and as outside counsel, in my own firm and in the large patent and intellectual property firms as well. Currently, I am Vice President of Government Relations for IEEE USA, and in that, which is my volunteer gig, basically I advocate for the IEEE US members on any issues that are important to themselves personally or most especially for their careers. That means that we will advocate to all the branches of the government for on topics ranging from cybersecurity, immigration, intellectual property laws, communication policy, transportation, drones, aerospace, any number, R&D funding. When we think in the abstract, we recognize that business itself involves the acquisition and exploitation of ideas. And in each one of those aspects, certain information is developed, ideas are created, and intellectual property is the means of protecting those. Now, in every business, one needs to know, for example, in the acquisition of ideas, whether or not to create the ideas themselves or acquire them. And intellectual property is the way by which those ideas are exchanged. For example, when one creates a does the work themselves, the classic make versus buy decision. In the make decision, one creates the property themselves, and then the various forms of intellectual property will be the means by which that could be protected. And we'll go into those in a little bit more detail later. If one decides to acquire the rights to particular ideas, that would be done by creating some form of strategic alliance, for example. It may well be that you acquire them by hiring the person who can develop them for you, or it could be that you acquire them through a partnership with another company, or maybe it's a hands-off negotiation where one licenses the information or ideas from another. That is a contractual form of law that one uses based on the kind of the intellectual property in the ideas that are going to be exchanged. And in the exploitation of the rights, one decides, for example, is going to be a good or a service. Are they going to be purchased by individuals, by companies, or are they going to be perhaps licensed? Are you going to keep title yourself? And then what you would do is give a bundle of rights to another to use certain aspects of your idea. And that, again, is based on the intellectual property and the ideas themselves. The point is that which way to protect those ideas will depend on the area, the particular stage in which you are operating. For example, a new product being developed, not public yet, that might be protected by trade secrets. If the idea is going to be going out into the public, other areas of intellectual property would need to be involved. For example, patents, trademarks, trade secrets to a certain extent, because if you can keep it private while still allowing access to the service, for example, then trade secrets still would be in play. Trademarks is another example. So what they have in common is that they all provide a certain amount of protection. They will provide, they all protect an intangible work product, and they are available for certain periods of time depending on the kind of intellectual property that we're talking about. Today, I think what we're going to focus on is the patent part of it, recognizing that patents are a right given by a government to an individual or an entity for the privilege of, it's a quid pro quo. If you disclose your idea to me, then I have the right to exclude others from using my idea for a certain period of time. Now, the thing to recognize is that each country has its own patent laws. So what's patentable, how long you can protect it, what is the scope of protection that you receive, will all depend on each particular country that you're operating in. So, for example, an Argentinian court won't necessarily protect a U.S. patent. It's protectable in the U.S. If you are acquiring the rights to a Malaysian patent, you're not going to be able to enforce it in Australia, for example. In the U.S., certainly if you have a U.S. patent and somebody creates a product that you view to be infringing, then you might be able to protect it in from being imported into this country. But that doesn't necessarily mean that if that import goes to another country, you'll be able to use your patent to protect it. So that's what I mean by geographic. The point that a couple of points that are important for a startup to understand is that patents are time barred if you do certain things. For example, we in the U.S. we do have a grace period, but it's not necessarily a very strong grace period. We have a situation where we have new patent laws where it used to be that if you had a year to get your patent on file after you made a public disclosure about it. Now there is that grace period under the new patent laws, which came into effect in 2013, but it's not as strong, it's not as vital. You could lose the right to your patent if you don't get it on file before your public disclosures. So the thing to recognize about this is that you may well have the great idea, but you might lose the rights to it. And part of this problem comes from when you have the great idea, the innovation, you start talking about it. You may need to, because you have a need to get capital from a venture capitalist, or you want to team with another company. But the point is that you need to make disclosures about your idea before your patent is issued. Certainly, the problem with issuance is that it can take 3 to 5 or even more years to get something issued as a patent. However, if you've got your patent application filed, then you can make your disclosures and you would be okay. Okay, trying to shop around an idea without having a patent application on file, with or without a prototype, but just trying to find a patent, trying to get money, for example, from it can doom the product because of what I was telling you about the grace period. The thing to remember is that patents are only going to get, the idea is only going to get marketed, is only going to get developed and marketed if there is some potential for making money. And venture capitalists most certainly will ask you, is there a patent on this? Because they want to make sure, number one, that you're serious about your innovation, and they want to make sure that there is some potential for their return. And they recognize that there are not that many ways to keep competitors at bay, and patents can be one of them. And so that's why they care about that. Now, if you are in a position where you don't need venture capital, God bless you, that's fabulous. Odds are you are going to need to market. You are going to need probably to have strategic alliances to market. You're going to need distributors. You're going to need all manner of activity. And if you start that activity without your patent on file, you may lose the rights to the patent because your competitors will be able to adopt your idea, and they might do a better job of running your business, of running the business than you. So you might have had the great idea, but the competitors might be the ones eating your lunch. So that's why you also need to make sure that you have a patent as well. The thing to remember also is that you want to be able to not be that company where you've lost your great idea, because although it's very important to continually innovate to keep ideas fresh, to keep your products fresh, revs, updates, upgrades, the fact of the matter is you have to continually patent the innovations as well. However, you don't want to be the company that, because you've lost your right to the great idea, you can only get patents on the follow-ons and you can only get patents on the improvements. You want to be able to protect your fundamentals of your business as well as your improvements. Okay, what you need to remember is that a patent is a business tool. It is not the solution to your business's. It's not the key to your business's success. It's one of your keys. What you need to do is you need to have recognize that it is a business tool to help you in success. It's not your only tool. What you have to focus on is the other parts of your company as well. Your marketing, your customer service, your product development, your quality. All of those things are really important. Patents can be useful, but they are not everything. Okay? Okay. Earlier, I was talking about how trade secrets can be very important, especially before your information, your product comes to the market. What you need to remember about trade secrets is that they are forever if they are kept appropriately. For example, the Coca-Cola formula is still a really valuable trade secret. And the reason it's a trade secret is because it's an item of intellectual property that adds an advantage that you possess that your competitors do not. And the other aspect of it is that you've taken the time and effort to keep it secret, so that you have been careful not to disclose it. You have used reasonable safeguards to keep it so. You have managed your relationships to make sure that your trade secret is kept secret. When we look at trade secrets, we have to realize that you do need to make disclosures. Use them sparingly. make your disclosures sparingly. Make sure that you are only disclosing information that a strategic partner needs to know. So that, for example, if they need to know the parameters, the characteristics to be able to help you to develop the product, for example, if it is a supplier or a vendor, then give them that information. But don't give them things that they don't need for what they're working on right then. The other thing is that you need to be careful to use non-disclosure agreements appropriately. Now, non-disclosure agreements will be enforceable if they are of the appropriate scope, if they are targeted, if you have identified what the trade secrets are, you have developed a relationship of trust, and you manage the process. You don't just make a disclosure and then let it go at that. You continually remind the parties that you're working with that yes, this is confidential. You mark it. If you say something in a meeting, you follow up with a summary, not a full-blown complete description of everywhere you absolutely said, but a summary of what we talked about. Remember in our conversation that we talked about the business plans of our company and our future product lines, and that is considered confidential to our company, as an example. The other thing is that you need to make sure when the company doesn't need information, you stop the information flow. You don't keep them on distribution lists. You make sure that when you send an email, you're not saying everything. Sometimes you need to give them documents that aren't necessarily transmitted, but if they are transmitted securely. You manage your distribution list so that you take people off that don't need to see the information anymore. You recognize, you keep your eye out. You don't partner with people who have a reputation for not for not keeping secrets. You are careful when you work in other countries, for example, some of which might not have the same reputation for secrecy as companies in the US do. You have to be careful to manage those more closely. And in the other way, when you receive other companies' confidential information, you make sure that your non-disclosure agreement is not overreaching. You may say, look, I only want to hear about your business plans. I don't need to hear about X, Y, and Z. If you hear about X, Y, and Z, and then they accuse you of misappropriating X, Y, and Z, well, it's better not to have ever heard about X, Y, and Z. So you need to make sure that when you're signing non-disclosure agreements, that they are tailored for the disclosures that you have to receive, and when you don't need the information anymore, that they are that you return the information, that you don't accept information from them anymore. You protect yourself in the same way that you are protecting their information. The other thing that you need to realize is that one major way that trade secrets can be lost is through terminated employees or business partners who are no longer business partners of yours anymore. It has been said that trade secret law is the divorce law of the business world, and it can be, and it is often driven by hurt feelings. What you have to do with your business's confidential information is make sure that it is marked. Make sure that you let an employee know that you consider this to be a trade secret. If you're not letting an employee know that it's secret, then the employee might feel like that he or she has the right to take it away. Because employees are allowed to take away from employment matters of a general nature. They're not allowed to take away matters of a specific nature. So you have to manage your relationship with your current employees, and you have to manage your relationship of your departed employees. When they leave, you sit down and you talk to them and you say, these are the things that are considered confidential by the company, and so these are the things that we do not allow you to use in future. The point that I want to make up here is that no man is an island. Back in the day, Actually, for a large part of my career, I truly thought that if one learned the rules of an endeavor, then, you know, if you learned the rules of the game and you played the game by those rules, sometimes you'd win, sometimes you'd lose. But the point is that if you knew the rules of the game cold, and if you applied them in a strategic and a thoughtful way, you could find a way to increase your chances of winning. And I think that kind of used to be the case, where not only in your personal life and in your interactions, but I think it applied to everything. For example, in starting a business and having a product, what you might have is the rules, for example, of developing a product, using the using the science, that's a set of rules after all, using your engineering, using good practices in product development. You increased your chances of having a good product, and it held us in pretty good stead. I have learned the hard way that that doesn't apply in every endeavor. One of the things that I have learned is that certain rules are changed and changeable, and you need to have a voice in those rules. The example that I use, and what changed it for me completely, was when the America Invents Act was enacted in 2013. I was not that worried about patent reform because I had confidence that, well, I'd just learn more rules, I'd figure out how to use those rules and the processes and procedures for advocating for my clients and obtaining intellectual property protection for them. What I was not counting on was what turned out to be the case, which was that the American Invents Act constituted the most significant patent reform in well over half of a century, and essentially turned out involved rules of action that are skewed toward big businesses and against individual inventors and small businesses. You know, we had all been expecting patent reform. There was all kinds of debate going on about what it might be, what it should be, but there was some sort of a confidence that things were going to be okay. Not necessarily. I'll give you an example. We talked earlier in another discussion about the grace period, where it used to be that you would have a year after an initial disclosure to get a patent application on file. Other countries did not have the grace period. They were jurisdictions that we called absolute novelty jurisdictions, where if you didn't have an application on file before you made a public disclosure, you lost the rights in that in being able to get your idea patented, your innovation. We unfortunately are moving toward that in the U.S. And we still have a grace period, but it is a weak one because of all the uncertainties involved in the new language that was used to create the grace period. We have uncertainty which is going to last for decades. So we're in a situation where we really still have to counsel our clients that they really need to operate in a way as though there were no grace period when there actually is one. Because we don't want to have our clients be those companies that lose the rights to patent their great idea because they were, for example, trying to build a business, that they were trying to get capital to finance their business, that they were trying to develop distributors in anticipation of that business. And the one of the scary parts of it is, for example, they might make a disclosure which is overheard by a competitor, and the competitor gets a patent on the idea that is not theirs. It might be slightly different, and because of that slight difference, you might wind up having to have your competitor be your primary possessor of what you consider to be your intellectual property. The problem is that now government has changed the rules of the game. And at that point I learned that if I did not involve myself in how the rules were developed, the scope of them, what they should constitute, what their impact should be, then I was going to have to live by somebody else's rules and not the ones that are advantageous to me and to my clients. So what do I do about it? I came to the conclusion that I wasn't an island and I needed to do more in advocacy. I got myself involved with IEEE USA. IEEE USA is the U.S. branch of IEEE, the world's largest technical professional organization, and IEEE USA advocates to its members on issues that are of interest to its membership, most particularly in their careers. We have committees. I started with the Intellectual Property Committee because of my background as an intellectual property attorney, and I was able to get involved in speaking my mind to various parts of the federal government about things that I thought were important, the things that I thought were important to my client, in a way that just my writing a letter to my congressman was not going to provide. So through this committee, I'm able to, for example, participate in writing amicus briefs. Amicus briefs standing for amicus curiae, which is friend of the court, where organizations and individuals can provide briefs that document how something about a case that's before the court. We at IEEE USA try to write amicus briefs that will provide a technological context of the issues that are before the court. So that's one way we're able to provide influence. The other things that we do is provide advocacy in Congress. There is still talk about additional patent reform, and IEEE USA is making it the voice of its members known. The third branch of the federal government is the administrative one, and the U.S. Patent and Trademark Office is part of that administrative branch, and we provide comments to the U.S. Patent and Trademark Office about areas where we think that they could improve their efficiency and responsiveness to their client base, which is to a very large extent IEEE's membership. Basically, what we need to understand is that technology and politics are inextricably intertwined today. Everything we touch has a technological focus. Cybersecurity, energy policy, the drones, what to do about AI, what to do about immigration, all have technological undertones. And the audience that we're talking about here, academics, they have a scientific bent. They have a knowledge space that they could share. And one of the ways to do it is to get active in advocacy organizations, whether it's the American Chemical Society, IEEE. The fact is that there are a ton of them out there, and I urge everybody to make your voice known, make your voice heard. The other thing to realize is that when you're doing this, you are meeting movers and shakers, not only the people in Congress, the people who are running the agencies who you need to interact with, whether it's because of regulatory aspects for your medical product, your medical device product, or whether it's the U.S. Patent and Trademark Office, or whether it's the SBA. Right. The other thing to realize is that besides meeting the congressional representatives that you have. You're also meeting their staff. And these people have a future. And what you are doing with advocacy is setting the stage. You may not get your way every single time, but if you are a voice of logic and reason, they will count on you and they will hear your voice more in the future. So the way that politics operates is you don't win all the time, but you set the stage for what you care about later. You make concessions for the things you don't care about, and you set the stage for the things that you do care about. So you're not only meeting your current representatives, your current legislators, but you're meeting their staff, and they're going to be important people in the government in the future. That's number one. Number two, you're meeting colleagues. You're meeting people that are in your industry. You're meeting people that can make a difference to your company in future years, whether it's meeting prospective strategic alliance partners or meeting your competitors. And if you understand each other a little bit better, cordiality never kills. You can learn a whole lot that way. So you're information gathering, you're building your network, you are setting your company up for success in the future. I cannot recommend it highly enough.
Fantastic.
The thing to remember about intellectual property is that you need to be careful to not leave anything on the table. Use it as the business tool that it is. Manage it like it is an asset, because it absolutely is an asset. You want to make sure that you are mindful. You need to use it as a tool, recognizing it's a long-term tool. The fact of the matter is that you got a lot of short-term problems. We always do, and it's always our tendency to address the short-term problems and leave the long-term problems for later. But you need to think about the impact of those long-term problems on your short-term decisions. And intellectual property needs to play a part in that. That's my summary for that that part of my talk.
Sure. Are there certain rules or laws that people starting out need to be cognizant of, or questions that you get hit very frequently that people generally are less aware of, but it would make their life much easier?
Well, the thing to remember is I continually hear, well, I'm going to get a prototype, I'm going to shop this around, and then if I find a positive reaction, then I'll get patent protection. You know what, honey? It might be too late. So you got to be careful about that part of it. Maybe what you need to do is use the provisional patent application system. The thing about provisional applications is that they do need to be written to the same level of detail as a non-provisional application, but the filing costs are less, and you don't have you do not have prosecution of them. So what you need to do is disclose in as much detail as you have right then what you have as your provisional application, revisit it in a couple of months, fill it in, amplify it. You got another provisional application on file. You might do that through the entire year, recognizing that when your provisional application has been pendent for a year, if you need to file a non-provisional application by the 1 year anniversary, or it goes expired. But what you can do with that 1 year is that you can take all of your non-provisionals throughout that year and bundle them up into one, which will get prosecuted. That way you're able to take your great idea, to capture your follow-ons and improvements of that year and get a larger, richer, more current patent application in the process. So it is one of those times where file early, file often can be to your advantage.
Okay, your second topic is focused advocacy.
Right. No man is an island.
Okay.
You really need to do yourself a favor for your career, for your business's success, and get out of your office every once in a while and try to make a difference. It will not only feel good, it will take time that you feel that you don't have, but in the long run, it will allow you to influence the shape of your future. Yes. Okay. Now, what we need to understand is in the abstract, all of business is either acquiring or harnessing rights, assets. And intellectual property is actually both. It is an asset. It's as much an asset as your real estate or your desk is. It's just not tangible. It's the work product that you develop in through your efforts. And when we are in a business, what we need to do is figure out what we want to do. Then we have to ask ourselves, what rights do we need to be able to do what we want to do? And then we have to implement our plan for doing it. And the kind of rights that we're talking about are intellectual property. They can be patents, they can be trade secrets, they can be trademarks, they can be copyright. But what we need to remember is that when we have a set of rights that we are putting into a business plan, at certain stages of that plan, they will either be held secret within our company or they need to be disclosed in order to be able to make them available to the public. And what kind of protection you would apply to each one of those particular assets depends on where you are in your business plan. For example, if you are developing a product or a service, you may decide that what you want to do is keep it secret until it's ready, until the product or the service is developed, ready and vetted, ready to be sent to the public. You would keep that confidential within your company if you don't want other companies to exploit it, for example.
Right.
If you are ready for it to go to the public, well, you can't use it as a trade secret anymore because trade secrets require secrecy to be valid. Trade secrets can be forever. For example, the Coca-Cola formula is something that was developed over 100 years ago, and it is still not known. It's still a valuable trade secret. But not all assets are like that. And so, for example, if you need to make it public, then you might decide that, for example, software might be kept, parts of it might be kept secret. You might not disclose parts of it. Parts of it might be patentable subject matter, and so you might decide that you get a patent on that. Your source code, your documentation, your user interfaces might have copyrightable components in them. So what you do is when you look at the thing, you don't say, well, it's only going to be one way that I'm going to protect it. I'm going to target my protection strategy based on what I have available. Now, what these areas all have in common is that they protect the intangible work product, they grant a measure of exclusivity, they're territorial, so a Malaysian patent won't help you if you are selling in Japan. A US patent will help you in the US. So we talked about trade secrets, and I can tell you a little bit about patents now and how they relate to a startup company's strategy.
Sure.
What we need to remember, and this is a real challenge for startups, is that patent protection ideally should be in place before they start making disclosures of the great idea to the public, whether it's a set of investors or whether it is looking for strategic alliance partners. When an idea is disclosed publicly, it is now at risk. We have a grace period in the United States. In other countries, it's an absolute novelty situation where you open your mouth, you lose your rights, period, boom, that's the end of it. In the US, you do have a grace period. The laws changed on the grace period in 2013, and instead we have a situation where the grace period is more uncertain, and it's especially uncertain about if you disclose your idea. Is the patent that you have going to get on that idea going to be able to protect you for follow-ons or implementations or alternatives, and so that's a little bit uncertain. So our advice is still to get a patent application on file. Now, before you make a public disclosure, you can get a provisional application, but what you have to understand is that the provisional application still has to be as detailed as a regular patent application. So it's not as though you're going to save effort in getting your patent application on file, but what you'll get is that you're not going to have to prosecute your provisional application. It has to be turned into a non-provisional within a year. So the trick is that, okay, let's say you file something in March, you got to look at your portfolio again maybe in a couple of months and say, have there been follow-ons that aren't covered by my provisional? And you got to get that on file as well. So throughout that year, you can file a lot of provisional applications to take care of your implementations as you develop it. And then in March again, by that 1-year anniversary, you have to be you have to file a non-provisional, and you can bundle all of them into one, and that will help you with the prosecution costs of a patent application. One of the things to realize about disclosures is in the decision about should we get a patent or should we not get a patent? One thing we really you have to understand is that venture capitalists still like to see that you have a patent portfolio. It does a couple of things. It says, I am serious about my innovations and I want to be able to protect, them. It also says that if others start using that idea, I've got something that I can use to protect myself against basically people that are impinging on my idea. And venture capitalists are very interested in finding out what kind of return they can have on their investment. And so without protection available, their investment is at risk. So it's important, if you're one of those companies, and most of them are, about needing to get funding, you need to seriously consider getting a patent portfolio. And more patents is better in this particular case. One great idea is one thing, but it may be a situation where you actually need a portfolio of patent protection instead of just one.
Sure. I have a very, maybe a naive question. Let us say it's an expensive process.
It's an expensive
you're
process.
Starting out, you're trying different prototypes. Sure. If you can't afford to have a patent right away, till you have a steady flow of income, what is the minimum procedure, or what is the minimum tactic that you could use so that you still retain the intellectual property as an asset?
Well, it is an expensive process, yes, and there are some organizations that do pro bono work in getting patents. The U.S. Patent and Trademark Office has information on its website, uspto.gov, about these organizations. But I'm not going to be able. I wouldn't count on it. There aren't that many, and it's very hard to obtain. So sometimes it's one of those things where you just have to do it, unfortunately. But you can, as I said, you can get a provisional application, and throughout the year have a series of provisional applications, so that when you are at the year anniversary, you're covering more than one idea of yours. So that's one way to cut a few costs. It's a reality of business, though, and it's an expense of business that you're just going to have to find a way to do. If you don't have patent protection, you leave yourself open to competitors taking your idea, and that is a significant risk. You may be in a situation, you may be in an industry where patenting is not important, but I can tell you that patenting is extremely important when your competitor is starting to eat your lunch. The other thing to realize is that also a lot of startups have in their head that they're going to be acquired by another company. And one of the things that will boost their value is a patent portfolio. So it's something that cannot be ignored as much as you'd like to. One of the things that I want to point out, though, is that, of course, the best strategy when you're dealing with competitors is to continually innovate. You've got a great idea. They come up with something that's similar or not similar, but the way to boost your idea in the marketplace is to continually innovate. The thing to remember about a patent, though, is that it is a business tool. It is not a means to, it's a means to an end. It's not a be all and end all. So that, let's say you've got the great idea and your competitor has something that's not quite as good, but your competitor might be better at things that you are. It might have better connections, it might have better marketing, it might have better quality control, it might have better customer service, and all of those things could lead to your competitor having more success than you do. Having a patent is an important thing, but it's not everything. Okay? Trademarks identify the source of a good or service. They can last forever if you monitor them, if you make sure that others are not using them, and if that others are using them correctly. So there are two important components that I want to emphasize here. Selecting a good trademark. Try to identify a mark that is gonna be distinctive, might be the tiniest bit suggestive of your product or service, but doesn't describe it completely. Be careful. For example, Digital was a terrible name for a computer company because computers were digital. IBM, although an acronym and though therefore dangerous because it's not registrable in every country in the world, developed a secondary meaning as to what it is that the company stood for. Apple is a perfect example of something that was did not describe the product at all, but developed a secondary meaning as to products and services in the computer space. So when you start thinking about a great trademark, I urge you to do a lot of, I'm going to say this, a lot of Googling, which is incorrect trademark usage, and I'll talk to you about that in a couple of minutes. But do some online searching to make sure that somebody else is not using something remarkably similar to it. The question is always going to be, will an ordinary observer be confused into thinking that you are the source of somebody else's goods or service, or vice versa? So it's a question of whether or not there is a likelihood of confusion in the marketplace by your adoption of a mark. Now, the other thing to remember about trademarks is you need to use them properly. You need to use them as an adjective. Don't use them as a noun. Don't be that company don't be Zipper Corporation. Make sure that you are always using it distinctively. Sometimes you might want to use it with bold or italicized. Use a little TM. Never use an R in a circle unless you've actually registered it in the U.S. Patent and Trademark Office, and even then you probably shouldn't do that. And the other important aspect is to monitor other people's use, so that if you find that on the internet or in your dealings in trade shows, you find other people misusing your mark, you need to complain about it. You need to contact these other companies, say you are using our marks incorrectly. This is how we use them. Please use them correctly. Because again, if you allow others to misuse your marks, as if you misuse your marks, you can lose rights in it. Okay?